कि सर ये दिस अपील इज ऑन द ग्राउंड ऑफ फ्रॉड माय लॉर्ड। इसमें जो एक्चुअल एक्सीडेंट हुआ वो हुआ सर एक ट्रक से MTG 5608
5MP
MTG
MPG
MT सर T फॉर ट्रक
MT
जी MTG 5608
5608 जी
14/7/2004 को एक्सीडेंट हुआ
14/7/2004
7/2004
जी।
एक्सीडेंट किससे हुआ सर? अब सर जो क्लेमेंट्स हैं या जो नीचे क्लेम फाइल हुआ उसमें सर एक कवर नोट पेश किया गया वहां पर। वो कवर नोट नंबर था 058622
058686
058622।
हाँ
अब इसके बेस पर सर इन्होंने इसमें मैनिपुलेशन किया था और सर इसके बेस पर अवार्ड हो गया।
अच्छा
जी अब अवार्ड के बाद सर हमको जानकारी जो है वो बाद में मिली कि सर ये जो कवर नोट है एक्चुअली ये कवर नोट जो था सर एक स्कूटर का है।
अरे
जी तो हमने सर उसके बाद रिव्यू एप्लीकेशन फाइल करी।
हाँ
वो रिव्यू एप्लीकेशन के साथ हमने सर ये कवर नोट और जो पॉलिसी है वो लगाई वहां पर।
हाँ
तो सर वो रिव्यू हमारा रिजेक्ट हो गया कि ट्रिब्यूनल ने ये बोला कि द ट्रिब्यूनल डू नॉट हैव एनी पावर टू रिव्यू इट्स ओन ऑर्डर।
ठीक।
ये हमारी अपील सर उसी ग्राउंड पर है।
बताइएगा तो पहले कोई लॉ लाए हैं ट्राइब्यूनल, वेदर ट्राइब्यूनल हैज अ पावर?
ये सर एक सुप्रीम कोर्ट है
दिखाइएगा।
2000 ACJ 1032। फ्लैग लगे।
यस
एक सर 2 जजमेंट्स और हैं सर।
ठीक है ठीक है। यस बताइए कि कवर नोट का कहाँ है?
ये सर हमारा जो सर जो ऑर्डर है इसमें
रिव्यू का ऑर्डर।
रिव्यू का ऑर्डर
हाँ पढ़िएगा। जी
ये सब पैरा 2 में आता है।
जी
आवेदक का आवेदन संक्षेप में इस प्रकार है कि अनावेदक क्रमांक 1 के द्वारा इस न्यायालय में एक दुर्घटना दावा प्रकरण क्षतिपूर्ति राशि प्राप्त करने हेतु प्रस्तुत किया गया जिसमें ट्रक क्रमांक MTG 5608 से घटना दिनांक 14/7/04 को हुई।
ठीक है। चेतक बजाज चेतक का है।
जी लगाया है सर हमने अपील के साथ भी एनेक्चर A1 करके लगाया है।
बताइए भाई।
But as far as this aspect is concerned, Millets, before the tribunal they were present, Millets. They let their evidence in, but
लेकिन
this
सुप्रीम
aspect-
कोर्ट कहता है that if the fraud is committed then it can be 058622। ठीक है ये कवर नोट है। ठीक है नागपुर से जारी हुआ है 2/8/2000 से 1/8/2001 तक। ठीक है स्कूटर है। स्कूटर से ट्रक कैसे हो जाएगा? स्कूटर पेमेंट वगैरह कर चुके क्या इनको?
नहीं सर इंटरिम ऑर्डर इसमें हुआ था। हमने सर उस टाइम पर सर 25,000 ही जमा करके आए थे। तो सर 2/3/2007 को इंटरिम ऑर्डर था कि अगर कुछ डिपॉजिट है तो वो रिलीज ना हो।
This appeal is filed by the insurance company being aggrieved of orders award dated 7/10/2005 passed by Lalit Second Additional Motor Accident Claims Tribunal, Balaghat, MP, in MVC number 18/2005, Chunni Lal versus Jaipal Singh and others, whereby claim of the claimants was allowed, full stop. It is submitted that incident took place on 14/7/2004.
2004.
It was alleged that claimants met with an accident with a truck bearing registration number MTG 5608, full stop. On the basis of such averments, claim was filed and that was decreed, full stop. Learned counsel for the insurance company submits that the cover note which was produced by the owner driver of the truck bearing number 058622 was discovered to have been issued by the office by Nagpur office of the appellant's company on 2/8/2000 for a Bajaj Chetak scooter registered in the name of Mr. Sunil, पढ़ सकते हैं क्या सुके क्या लिखा है, सुनील बी सुके SUKE, भूपेश नगर, बोरगांव, नागपुर, full stop. The policy issued under the said cover note was valid from 2/8/2000 to 1/8/2001, and therefore insurance company was liable to be exonerated. Next para. It is submitted that learned tribunal committed an error in not entertaining the review application, which is against the ratio of law laid down by Honorable Supreme Court in United India Insurance Company Limited versus Rajendra Singh and others, 2000 ACJ 1032, wherein the Supreme Court has held that if fraud is alleged, then the tribunal has power to review its order, full stop. It is held that no court or tribunal can be regarded as powerless to review its own order if it is convinced that the order was wrangled through fraud or misrepresentation or such a dimension as would affect the very basis of the claim, as it would lead to serious miscarriage of justice, full stop. Therefore, claim was remitted to the tribunal for fresh consideration. Next para. Shri Pravesh Navedia, learned counsel for the claimants.
Respond number 1, claimant.
For the claimants is not in a position to dispute this proposition. However, he submits that claim will still be maintainable, and in place of the insurance company, it will be payable by the owner driver of the offending vehicle, that is truck bearing registration number MTG 5608, full stop. Next para. After hearing learned counsel for the parties and going through the record, comma, firstly, the order dated 19/5/2006 passed by Second Additional Motor Accident Claims Tribunal, Varasivni District, Balaghat,
जी डिस्ट्रिक्ट बालाघाट
District Balaghat, cannot be sustained in the eyes of law in the light of the decision of Honorable Supreme Court in United India Insurance Company Limited versus Rajendra Singh and others, Supra. So also in the light of the decision of High Court of Judicature at Calcutta in New India Assurance Company Limited versus Shailendra Nath Bera and another, 2004 ACJ 1018, full stop. Therefore, the said order in review is set aside. Next paragraph. On appeal, it is evident, in appeal, from the appeal, it is evident that the impugned award and the order in review have been passed oblivious of the fact that there was a fraud, full stop. Any party who tries to take advantage of fraud cannot be allowed to succeed because that will put at naught any UGST, put at naught the basic purpose of expounding the rule of law, full stop. Once it has been established by the insurance company and not disputed by the owner and driver of the vehicle that their vehicle MTG 5608 being a truck was not insured with the appellant insurance company, award needs to be modified. Insurance company is required to be exonerated. Full stop. Award shall stand against the owner driver of the offending truck from whom the claimants will be free to recover the amount of compensation as has been passed by the learned tribunal. In above